So what this talk will cover this afternoon is common examples of where people or bodies can and will intervene, the relevance and impact of this in the current economic climate. Do you need to join a third party? When should a third party be joined to proceedings? Who should apply for joinder? Guidance on the procedure, a case law roundup, and some practical tips. And also consideration of whether there's any other options that could be in play rather than applying to join a party to proceedings. So looking at common examples of where parties are often joined or people are joined to proceedings is, for example, when the family home has been purchased with the assistance for a relevant relative or other third party. So what we saw following on from the credit crash and recession that followed on from the 2007-2008 financial crisis, where parties had been purchasing properties and needed assistance with deposits, for example, from family members or assistance in order to be able to obtain a mortgage. Those sorts of cases, when now coming through the divorce courts, can be quite difficult or contentious, with one party, for example, saying that the relative had provided the parties with a gift, because, of course, that in most scenarios, that's what they would have had to have told the mortgage company, and the other party saying, no, this was a loan, my parents never intended to give us that money, we were always due to pay them back. And that's quite a common example, particularly when there's been financial issues and people struggling to get on the property ladder. So looking at some practical tips now, and we talk about this a lot, but I think in terms of costs, it's becoming such an important feature now of financial remedy proceedings. And for MBL, I've also conducted a number of seminars on the issue of costs in matrimonial finance proceedings, because it's becoming increasingly important to look at cost all the way through the proceedings. Where are we at? How much have we spent? The consequences of adding third parties, as I've already said, really does escalate the costs and causes all sorts of issues in terms of who's successful, who's not successful. Remember, it doesn't start with a no order of cost provision when it comes to intervenors in preliminary hearings. And in the case I did relatively recently, when the intervenor and one of the spouses was successful, cost orders were made against the other party for a not insignificant amount, as well as them having to pay their own costs in a case where money was already tight. And the impact of the preliminary issue decision had a huge impact on the ability for the parties to be able to resolve their finances generally. And actually, any share that party was going to have had been hugely depleted before we'd even got to the next stage. And so it's so important to look at the cost benefits